You can tell everything.
Okay. All right. Good afternoon, everybody. Welcome to the Board of Adjustment study session. Today is June 29th, 2022. It's approximately 5 minutes after 1. And let me just pull up the agenda here for today. Okay, can everybody see my screen?
Yes.
Okay. So before we get started with the session, I'd like to go ahead and take this time to introduce our newest board member, and then perhaps we can just go around the room and just introduce ourselves. But we do have Irma Duran, who is appointed by the Vice Mayor Lane Santa Cruz, representing Ward 1. She just was sworn in and she's able to be a voting member of the Board of Adjustment. So I would like to give her a hearty, warm welcome. And if we can just go around the room and introduce ourselves so we can just all get to know each other. Let's start out with you, Chairman Marks.
Oh, okay. Well, my name is Michael Marks. I'm the chairman, appointed by Councilman Cunningham, and I want to welcome you.
I'm Bruce Dawson. I'm Ward 6, appointed by Councilman Kozaczek. Welcome to the board.
Thank you.
Hi, Irma. I'm Kathy Kubish, and I've been on the board for around a year now. So welcome. I think you're going to have an interesting time.
That's a good way of putting it.
Mr. Penny.
Hi there, I'm Lee Panyi, Ward 3, and I've been on the board for about 5 months, and just want to say welcome and thank you for serving.
Hi, Irma. I'm Miranda Schubert. I was appointed by the mayor to the board, and I've only been here for a few months. Welcome. I think it'll be interesting. It's been interesting for me.
Ms. Montes.
I am Sue Montes, City of Tucson Planning and Development Service. Welcome aboard.
Ms. Hamblin.
Good afternoon, I'm Elisa Hamblin. I'm the zoning administrator, and I am so happy to have Irma here and have a full board of adjustment. This is great for us. So thank you for your service.
Mr. Lusk.
Good afternoon. My name is Roy Lusk. I'm with the Tucson City Attorney's Office.
Mr. Lugo. Mr. Lugo, I think you're muted. Okay, we'll come back to him. Ms. Hanum.
Good afternoon. My name is Jennifer Bonham. I'm with the Tucson City Office.
And Mr. Berger.
Hi, my name is Wyatt Berger. I'm a planner with the Planning and Development Services Department.
And Ms. Pennington.
Hi, everyone. I'm Georgia Pennington. I'm also a planner with Planning and Development Services.
And Irma, I don't know if you have a camera on your iPad, but go ahead and introduce yourself. Oh, I think you're muted.
Hi, can you hear me?
Yes.
Great, thank you. Thank you all for your introductions, and I am honored and delighted to join the board and looking forward to my service. And well, thank you. Thank you so much.
Thank you, Irma. Okay, I'm going to share my screen again here. Okay, so getting back to the study session agenda, looking at July for next month, we currently don't have any cases scheduled. So it would be a little break from Board of Adjustment. But we do potentially have 3 cases that would be scheduled for the August 24th meeting. And I've listed the 3 cases that we could have. 2 of them are residential projects. The one on Grant Road is obviously a commercial project that's a restaurant. So those would be the potential cases for August 24th public hearing. If you know you're going to be out of town or not available to attend that meeting, please let me know as soon as possible, just to make sure that we do have a quorum for that August 24th meeting. Before we get started with today's discussion on our case, I just want to make sure that everybody did receive the study session packet that was emailed last night that included the approval protest map with the comments that have been received to date, and then also the materials for the reconsideration of case C10-2202 that was also attached to the email. If you did not receive that information, please let me know so that I can forward that information to you.
Oh, I got it.
Okay.
I got it all.
Yeah, I've got it too.
Okay, thank you. Okay, so getting to the topic of today's Board of Adjustment meeting, we have a case at C10-22-06. It's the Cornejo Residence 2-story addition, and it's located at 2246 East 6th Street, and it's currently zoned R1. So this is a property here. It's approximately a 6,700 square foot lot. And it's currently developed with a single family residence and 2 accessory structures. So the property is located on the southwest corner of 6th Street and Wilson Avenue, as you see there. 6th Street is a collector street as identified on the major streets and routes plan map. The applicant is proposing to construct a 2-story addition to the residence. And that blue triangle there indicates the location, the approximate location of where that 2-story addition is going to be. There is other additions to the south of that blue box. That's primarily a 1-story addition. It's just a 1-story addition to the south, but those additions do not need to have any requested modifications or anything like that. So just the portion in the blue square that seeks modifications to the setbacks. So as you see there to the right, I have them listed out what the setbacks are being requested before the board. So the first one is to allow the construction of the 2-story addition with a reduced front street setback from 26 feet 6 inches to 16 feet 7 inches as measured to the back of future curb along 6th Street. Number 2, allow the construction of a 2-story addition with a reduced side street setback from 29 feet to 20 feet as measured to the outside edge of the adjacent travel lane along Wilson Avenue. Number 3, allow the construction of a 2-story addition with the reduced side perimeter yard setback from 17 feet to 10 inches. I'm sorry, 17 feet, 10 inches to 11 feet, 5 inches as measured to the west lot line. And number 4, allow the construction of a second story porch with the reduced side perimeter yard setback from 15 feet, 5 inches to feet as measured to the west lot line, all as shown on the submitted plans. And let's move over to the next slide here. So this is kind of a zoomed in detail of the site plan, and hopefully it's the dimensions are visible. But as you can see, the front portion here is where the addition is going to be, like I mentioned, showing the setback reductions to the west, east, and to the north. Staff does not have any objection to the requested variances. On our visit, we observed several properties through the neighborhood with 2-story additions. And even so, there were several properties that have reduced setbacks. I want to know for sure that through the design development option, which is a administrative process for reducing setbacks, we've seen several cases in Sam Hughes neighborhood. And then there's also been a couple of variance cases in the Sam Hughes neighborhood as well. Okay, so this slide kind of shows the location and how those elevation drawings look to those sides where they're requesting reduced setbacks. So as you can see, the front is this portion here. So this is what the elevation from 6th Street would appear to look like. And then over here, we have the west elevation. This is the side that has the covered porch on the 2nd story. And then this is the east elevation here. This is what it would look like from Wilson Avenue. These are the properties that we observed when we did our site visit that were 2-story. So it's fairly close to the area. And this is within the 400-foot notice area. So to date, we have received a total of 3 written protests, 1 approval, and that was in the packet that you received. So at this time, this concludes staff's presentation, and I'm just going to go ahead and open it up to any questions from the board.
Yeah, Mark.
Yes.
So there's mention of the 2-story addition, but does the existing zoning allow the 2nd story? And is it correct that the variants relate to the setbacks for the 2-story, not the height of the 2-story? Is that fair to say?
Mr. Chair, to answer your first question, the height is allowed by right under the R1 zoning. So you can build, I believe it's up to 24 feet. I don't have that completely memorized. Okay. And the other thing is, so the setbacks are based on the building height of the wall facing the property line. So of course, the taller you go, the greater your setback is going to be.
So all the variances are setback related, not height related, although there's a relationship between the setback and the height. The height determines what that setback is.
Correct.
That's correct. And just to be clear, the reason why this is going before the Board of Adjustment and not through an administrative process such as the design development option is because 6th Street is identified as a collector street on the major streets and routes. And applicant cannot request a variance from a setback on a major street and route. So it had to be through the variance process.
So you made the point that there are other 2-story houses nearby and maybe along 6th, which is not necessarily directly to the point because two-story homes are allowed in the underlying zone. But are those two-story homes you refer to, are they a result of setback adjustments as well?
I would have to say it would depend on the year those projects or those homes were constructed or when those additions were done, if they were two-story additions. But I would say anything under the land use code and more recently would have gone through some process such as a lot development option, a DDO, or a variance process if it was permitted.
Okay. All righty. I think for now, that's all I have to ask.
Mark, I have a question.
Yes, Ms. Kubish.
Did we hear from the neighbors directly west of this property? I noticed that the protests were not adjacent. They were in the neighborhood, but they weren't directly adjacent. And it's that property on the west that's going to be most impacted by that setback and by the height. So any comments from them at all?
We did not receive anything approval protest form from that property owner, but I do believe, and you can ask the applicants during the public hearing, but I do believe that the applicants reached out. But they can correct me if I'm wrong, but I think they reached out and they didn't have any objections to that.
Okay.
Hey, Mark, I'm wondering, I did see the 3 protests, but I did not see the 1 approval. Was that in the packet?
It was in the packet. I believe it may have been the first comment form right after the map.
Okay, I'm sorry, I missed it.
They didn't give a reason, so it was kind of easy to miss. I have a quick question about, so in my experience and knowledge of setbacks, I feel like they're primarily something that's used for like privacy of, immediately like adjacent neighbors and things like that. Are there other reasons to have setbacks besides aesthetic?
So setbacks are, it's a standard. So it's a standard throughout the, through the zoning classification. And as we all know, these standards are not like a one size fits all kind of situation. But in cases like, the setbacks relate to protection, I want to say building protection, infrastructure. Maybe Ms. Hamblin, you have a better feel for that explanation.
Well, Mark, let me just say from an architectural and a code perspective, is that a lot of setbacks are based on, and that are in the uniform or the current building codes are based on fire protection for the most part. That certain buildings can't be within a certain distance from one another so that fire can't spread from one to the other.
Yeah, I was gonna echo that. So thank you for mentioning that. I mean, there is a minimum setback typically for building code of at least 3 feet. Zoning setbacks tend to be more than that. The rationale for them can vary, but typically when it's a residential to a residential, the rationale is things like, light, privacy, air circulation, those kinds of things. They vary greatly between communities. So Tucson's setback requirements are specific to Tucson. We have variable setbacks, which means the higher you get, the farther away from the property line you're supposed to be, which is not the case everywhere. And so that's the reason for the variance request today, is because those variable setbacks and the height of the building just pushes them, and they're, constrained by the size of their lot. So I think some of the considerations in the Board of Adjustment findings have to do with not putting a negative impact. Don't quote me directly on this because I don't have the findings right in front of me, but not having a negative impact on like the light or privacy or views or whatever of the adjacent neighbor. So those are some things that can be part consideration of the finding specific to any kind of setback variances and requests.
Thank you.
Any additional questions from the board?
Not from me.
Mark, what did Bruce, did you have a question?
No,
Okay,
I'm
because you're on my screen. No, I would just say, Mark, that while there are 4 variance requests which are distinct from one another, I understand it to be that in order to approve this request and to satisfy the petitioner's desire, we have to find all 4 variances acceptable. Is that a fair statement?
I would say so, because all those setbacks are tied to the specific design.
They're all interrelated. And one last question, is it fair to say that there was a neighborhood meeting and all of the immediate property owners were notified?
That's correct.
Okay.
Mr. Lusk?
Thank you, Mark. Chairman Marks and board members, I just wanted to clarify just briefly related to granting or denial of the variance request. The board can either grant, deny, and or modify the request at their discretion.
Okay.
Anything else from the board?
No, not for me.
Okay. Let's move on to the next item on our study session agenda. And I believe that was okay, so we have a discussion about the reconsideration request for C-10-2202. As you recall, that was a public hearing that was held last month regarding the lot split adjustment. And the applicant has provided some additional information that was not available at the time of the public hearing. So therefore, the applicant is requesting a reconsideration to hear new materials. So, and I think at this time, Ms. Hamlin, did you want to talk about procedures of how that works?
Sorry, I needed to unmute myself. I do have a couple of things I just want to cover on that reconsideration, and I'm going to pull up a slideshow, and if you give me just a second, because I'm apparently having some problems with doing that. I should have tested this before I did it. Hold on a second. So the board essentially has the task of deciding whether they want to hear the reconsideration, and then ultimately you decide at a subsequent meeting whether you want to adhere to your original decision or change the decision. So in the UDC, which is the Unified Development Code or the zoning code, it talks about a reconsideration. It's a 3-part test essentially that an applicant has to meet in order to be heard for reconsideration. So I highlighted the passages that you can see on the screen in 3 different colors just for ease. So the first is that there was an error in fact or law or in this decision. So basically there was an error in either facts or the decision of the case. You have to decide if that's the circumstances here. Next, you need to decide whether the party has new evidence or material. So whether you consider what the applicant is going to provide as new evidence. And then the third test is whether that evidence was available at the time of the public hearing. We can answer some specific questions on that in just a minute if you want some clarification. But the board rules offer some further kind of clarification on the reconsideration, just procedure wise, which I wanted to highlight for you. I only pulled out an excerpt of the board rule. I didn't want to do the whole entire thing, but you would make a motion on the request to reconsider for the previous decision. It carries by a simple majority vote. So we do have 7 members, so majority would be 4 votes. And then if you grant the request, it would be heard at the next regular meeting or the next scheduled meeting. So today you're going to decide if we want to hear the reconsideration. If you do, it gets scheduled as a new public hearing at the next meeting. If you deny the request for the reconsideration, the board needs to enter in on the record the basis for that denial, the reasons and the vote of the members. So that's just procedurally what we ask you to do. If this is a little bit irregular, we don't usually have a lot of consideration requests. So we're just trying to be really clear about what the expectations are of the board and what your task is for today's item. This is not a hearing today. We will be asking for your motion and your decision on this case during the other business item section of the agenda. And again, if your decision is to grant the request for reconsideration, and it opens up a new public hearing. So, and it gets noticed again, all of those procedures we would follow for a hearing basically start for the next meeting.
Ms. Hamblin?
Yeah.
It's my recollection through involvement in governmental bodies in the past, that the only party that can make only member of a board or commission that can make a motion to reconsider is a member that voted against the original motion. But you're not making any reference to that. Is that not the case? And that anybody, whichever side of the original motion they were on, can still make a motion today to reconsider the past decision?
Let me clarify that. So we as PDSD staff, and me specifically as the zoning administrator, I have received a request for reconsideration. My role is then to forward to the board this request for your decision. So if you see here on the screen, the section of the code that I have right now is the board may consider one request for reconsideration by the applicant or a party of record. I don't have the definition of party of record right in a second, but it basically means anybody involved in the case, anyone that testified, anybody that was part of the previous hearing record can request reconsideration. In this case, it is the applicant that is asking that. They filed a request with me, the zoning administrator, within 14 calendar days after the prior decision. And now at this point, I am presenting this request to you as the board to decide if it meets this 3-part test to be considered. I see there's a few hands up, and I'll defer to you, Chairman Marks, but I think Jennifer had her hand up first.
Chairman Marks, member of the board, I wanted to clarify that the request for reconsideration can be granted in a situation where there's an error of fact or law in the decision, or where a party has new evidence or material that wasn't available. So you don't need to satisfy both items. It can be one or the other.
Thank you, Jennifer. That's a very good clarification. I appreciate that.
So let me ask this. When this item is brought to us later today, all we're going to decide is whether we're going to reconsider it. And if we vote in favor of that, a motion to reconsider, we don't do anything further until a subsequent hearing date when we will.
Yes. Mhm.
But
That is correct.
the key element in the decision is whether there is new evidence. And I think we need some advice on how we define evidence relative to this decision. It's conceivable that a party could just repackage the same information, put it in just a different format and call it new evidence. But that's not the same thing as introducing a new fact or a new dimension that is pertinent to the case. That would clearly be evidence. So it is the question of what is evidence and whether the evidence purportedly presented to us is sufficient for reconsideration. Is that all our decision?
The criteria that we request the Board of Adjustment decide is whether it meets this item number 2 on the screen right now. So either there was an error in fact law or where there is new evidence and that evidence wasn't available at the time of the public hearing. So based on Jennifer's clarification, it's one or the other. So if you think there's an error in decision or you think there's new evidence, we will provide to you today during the other business item an explanation of what we consider, and I mean PDSD, we think that it meets the criteria as new evidence, and that's why we forwarded it to you for the board to consider as new evidence. There's not much more specificity in the code or in the board rules regarding what constitutes new evidence. So that could certainly be something that I think the board could discuss in the other business item today. And others have their hands up as well.
But curious one step further, you on staff have already seen or heard of the new evidence that we are going to be presented with.
Yes.
Are you giving us a recommendation as to your assessment of that evidence and whether it really meets a standard relative to a reconsideration? Or are you just putting it in our lap? And I don't mean that in a derogatory way, but are you just shifting it to us and having us decide when this matter is opened up?
We are not forwarding a recommendation to the board regarding the reconsideration. We are simply procedurally passing it along to you for your decision.
Mm-hmm.
We would not have put it on the agenda if we did not think it could potentially be considered to meet the criteria for a reconsideration.
Mm-hmm.
But that is your ultimate purview and decision of the board to decide whether it meets the test outlined in the development code.
Okay. And I think I just have one last question, and that is, are we limited in that matter to board members who attended the last hearing?
As far as who gets to make that decision, there is not any rules in the board regarding who votes on that reconsideration. So during the other business item today, it's a simple majority, yay or nay of whether you want to hear the reconsideration and schedule it for a new public hearing, there's not any rules about who may participate in that vote or not.
Okay, very good. That's all I have.
Miranda, did you? Sorry, Miranda and Kathy have been holding it. Go ahead, Miranda.
Thank you. So the document that was sent to us today looked really familiar, and I went back and looked through my emails. Unless I'm mistaken, we did receive this information prior to the May 25th hearing. From my perspective, I didn't use information that didn't take that into account when I made my decision. I also don't consider this to be new evidence. Those are my comments.
And I think, and one of the city attorneys can jump in and correct me if I'm wrong. At this point in the study session, clarifying questions are good, but regarding whether you agree or not, let's hold off to the other business item section, just so it's during the formal meeting. We can just make sure to get it documented correctly.
Can I ask the
mind.
clarifying question of, did we already receive this information?
I'm going to defer to Mark because he was the one that was sending out the information prior to the public hearing. So I'll let him answer that.
Yes, so the affidavit that we received, I believe it was the same day as last month's public hearing. That was, my assumption was that it was the David, that there was an error made in the legal description. And when we received the new legal description, which was just sent to me recently, yes, oddly enough, it did look the same thing, other than it wasn't an affidavit, it's just the new legal description. So it looked more formal. It was more formalized because it had the recordings information and everything else on that document. But I was expecting something else, but that's just, I thought it was different, but you're correct. It is basically the same language that we received last month. It's just a more formalized document.
And you should observe, I'm sorry to interrupt, but you should observe that there were some additional drawings and stuff we did not receive at the prior hearing, which I consider to be new evidence. And also an observation is that the reconsideration appears under new business, which is fine, but it appears after adjournment. So should the reconsideration be during the actual public hearing or after? Does it matter?
There's 2 adjournment items on the agenda. So we will adjourn the hearing for the case under consideration, and we'll move to other business item and then adjourn the other business items. So it's not a technical public hearing for the reconsideration today. And I do believe Mark can jump in and correct me if I'm wrong, that there was a presentation from the applicant that was not shared at the last public hearing. And I think that's maybe, Bruce, what you were referring to. But I'll ask Mark to just clarify that information as well.
That's correct. Yes, that was a presentation.
Okay, I'd like to jump in here if I may. If the petitioner wants to give a PowerPoint demonstration, then I suppose they should be allowed to do so. But it seemed that one of their main basis of their new evidence consisted of a scrivener's error, which replaced the deed on the east parcel, which was, it didn't matter. There were 2 deeds, one for parcel 183, which is the east parcel, one for parcel 184, which is the western parcel. It's the western parcel that they want to split and add the driveway, add the easement. Although the deed for parcel 183, the east parcel, was incorrect and has been corrected now. The deed for the west parcel came through first. I was looking at the assessor's record map, and the eastern parcel has 77 feet east to west. And I wondered how that was so, because I also looked at the vesting deed, and it was clearly incorrect. But the fact that the deed for the west parcel was filed first meant that it took precedence. And so the mistaken legal description didn't matter, because it was filed after the vesting deed for the west parcel. So their new evidence is really irrelevant. Now, if they want to do a PowerPoint, I suppose we should let them do that. But if they're using this Scrivener's error as their new evidence, it's irrelevant. It doesn't matter. If you look at the assessor's map, the correct description is already on that map. So.
And we can discuss the merits of the reconsideration item further during the other business item. I see that Roy has his hand up. Did you want to offer any clarifying items on this before we move on?
No, I just wanted to reiterate what you just said, Elisa, that discussion of the actual matter needs to be preserved for the public hearing portion of today's meeting. Just because, one, it gets reported along with the public hearing, as well as it provides an opportunity for response from anybody, including the applicant, during that discussion. So we want to make sure that the study session is mainly for the ability for the board and to have their answers or their questions answered by staff and the applicant and any other who attend the study session. Thank you.
Thank you. I'll turn the time back over to you, Mr. Marks, if you'd like.
Yeah, I've got one more question on this procedurally. And I appreciate the comments just made by Mr. Lusk. But I want to make sure I understand what we're doing procedurally here. When we get to this item, we open it up, even though it's not a public hearing. And the purpose is for the petitioner to present to us what he or she believes is new evidence. I presume we're free and may be obligated to hear what that new evidence is. And then when that is completed, all we're doing is voting on a motion that expresses our position, whether that evidence is sufficient to have a new public hearing. But we're not deciding on the reconsideration, we're on the substance of the matter. We're just deciding on whether that evidence is sufficient to warrant a reconsideration.
That is correct. So I'm just going to repeat basically what you said during the other business item. You are deciding, and you can invite the applicant to provide information to the board and give a presentation of what they consider to be their new evidence. You are deciding whether there was an error in the decision or there was new evidence that was not available at the time of the hearing. That's simply what you're deciding today, if it meets one or the other of those criteria. If it does, we're bumping it to a public hearing for the next Board of Adjustment meeting. Mm-hmm. We're not asking you to provide a decision on that variance request today, simply whether it will or will not be reconsidered. Jennifer?
When you deny the request, you also have to state the reasons for your denial on the record. I think Elisa covered that, but I also wanted to reiterate it now.
Thank you.
Sorry, it actually looks like to me we're actually voting to reconsider.
Yes.
I mean, I hate to say, but it looks like that we've seen the evidence. They presented it to us, sent us over the email. And so what's on the agenda item is reconsideration request for C-10-2202. And isn't that what we're voting on? Is we're going to hear it? And so once we voted on to hear it, that we go on and have a public hearing on it. It's not voting to whether we think the evidence is correct or not. Obviously, we're either going to hear it or not. Thank you.
Thank you, Bruce. I don't have any further direction on that item at this time.
Mr. Chair, I have it's 1:51. We can adjourn the study session and start the public hearing.
Let's do that. And do you mean we will open the public hearing immediately at this point?
That would be fine, Mr.
Well, that's
Chairman.
fine with me too. So let me turn to Ms. Hamblin and ask for a roll call.
Michael Marks,
Here.
Bruce Dawson,
Here.
Jesse Lugo, thought Jesse was here, but it doesn't. Jesse, you're muted. You here?
Here.
Thank you. Kathy Kubish,
Here.
Lee Pagney,
Here.
Miranda Schubert,
Here.
Irma Duran.
Here.
Thank you. Mr. Chair, we have a quorum.
Okay. Well, let me start with some preliminary comments for the benefit of the public members in our virtual audience. Want to welcome you to our regular meeting of the City of Tucson's Board of Adjustment. This meeting is being recorded, and by joining the meeting, you are giving consent to that recording. We have one item on the public hearing agenda today. After that case is introduced, staff will present its staff report. Board members may then ask staff questions. After that, the applicant or his or her representative will have time to speak. Other people, first those in favor and then those in opposition, will have an opportunity to speak as well. The applicant will then be given an opportunity for a rebuttal. Throughout this period, board members may ask questions of the applicant and other speakers. When all of that testimony is completed, the board will close the public hearing, discuss the matter, and then vote on a motion made and recorded by board members. All those who wish to speak will be asked to first state their name and address for the record. All of those wishing to speak other than the applicant should indicate that wish and your name and address in the chat feature. All presentations today must be directed solely to the board and not to staff or members of the audience, and all must be related to the case at hand and not to any other matter. For those who wish to speak, we ask that you be brief and to the point. Repetition of testimony already given by other witnesses is not necessary. If necessary, I will invoke a time limit for all speakers. Please remember that all testimony given today must be given under oath. And a reminder, please be sure to mute yourself and turn your camera off unless you are addressing the board. The decision of the Board of Adjustment may be appealed to the Superior Court of Pima County by filing a complaint for special action with the Pima County Superior Clerk's Office within 30 days of the board's decision. For additional information on this filing process, please contact the Superior Court Clerk's Office or an attorney after today's hearing. At this time, I am going to ask city staff to raise your right hands, and if you could turn your cameras on. And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Did I hear that from everybody?
I do. Sorry, I had
Okay.
to unmute.
Okay, thank you very much. And at this point, we will start the first hearing, and I will turn to Mr. Castro for his staff report.
Thank you, Mr. Chair, members of the board. Today's case is C10-22-06, Cornejo Residence, two-story addition, Erica Cornejo, 2246 East 6th Street, R1. The applicant's property is an approximately 6,750 square foot lot, zone R1, a residential zoning classification, and is developed with the single-family residence and two detached accessory structures. The property is located on the southwest corner of 6th Street, a collector street identified on the major streets and routes plan map, and Wilson Avenue. The applicant is proposing to construct a two-story addition to the existing residence. The applicant is requesting the following variances. 1, allow the construction of a two-story addition with a reduced front street perimeter yard back from 26 feet 6 inches to 16 feet 7 inches as measured to the back of future curb along 6th Street. 2, allow construction of a two-story addition with a reduced side street perimeter yard setback from 29 feet to 20 feet as measured to the outside edge of the adjacent travel lane along Wilson Avenue. 3, allow the construction of a two-story addition with a reduced side perimeter yard setback from 17 feet 10 inches to 11 feet 5 inches as measured to the west lot line. And 4, allow the construction of a second-story porch with a reduced side perimeter yard setback from 15 feet 5 inches to 5 feet as measured to the west lot line, all as shown on the submitted plans. The engineering section of Planning and Development Services Department has no objection or adverse comments. Planning and Development Services staff has no objections to the applicant's requested variances. It is the opinion of staff that there are special circumstances applicable to the property. The granting of the variances will not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located, and that the variance requested is the minimum necessary to afford relief and the least modification possible of those UDC provisions which are in question. To date, we have received a total of 1 written approval and 3 written protests. In summary, the protests indicate that the scale and architectural style of the project is not compatible with the neighborhood. For the record, board members have been provided a copy of the submitted comments. Mr. Chair and members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Well, thank you, Mr. Castro. I personally don't have any questions for you. Let me turn to the other board members and ask, do any other board members have a question for Mr. Castro at this point?
Yeah, I do. You were saying that the addition, the staff report is that the addition doesn't meet. Could you repeat what you said on the very end of your presentation, Mark?
Mr. Dawson, are you asking whether the first floor addition remodel is needing variances? Is that what you're needing?
No, you said something about the scale or the scope of the project not meeting. I'm sorry, I did miss that kind of part there.
So the in general, the summary of the protests received indicate that the scale and the architectural style of the project is not compatible with the neighborhood.
All right, that you were just speaking from the standpoint of the protests and not from staff. Okay, thank you.
Correct.
Okay, are there any other questions from board members? And if there are not, let's move forward and ask the petitioner to appear and announce him or herself, and I'll swear him or her in at that point. Is the petitioner present?
I am.
Okay, good. Could you raise your right hand, and do you swear to tell the truth and nothing but the
I
truth?
so affirm.
And could you state your name and address for the record?
My name is Erica Cornejo. Can you hear me all right?
I can.
Okay, good. Cornejo, and my address is 2246 East 6th Street, Tucson, Arizona, 85719.
Okay, very good. Why don't you give us your presentation, explain the request in ways that maybe weren't explained to us before, defend the request in terms of the hardship that you feel you have, and talk about the immediate neighbors, which I think we're interested in, and anything else you feel is pertinent.
Well, first of all, I just wanted to say thank you for the opportunity to speak to the board. And I'm grateful for your contribution to our community. I know it's an important work, so thank you for the opportunity to speak. First, I'm going to address all of the things that you asked me to, but I may go a little bit out of order from the way that you spoke. First, I'd like to address some of the concerns brought in by the written comments. First, that the character or the visual style is not consistent with the neighborhood. First of all, I'm not a house that contributes to the historical neighborhood. So I'm not getting that tax exemption on the house. So I already don't contribute. However, that being said, the style that I'm switching is from Spanish eclectic to Spanish colonial. And I've worked with my designer to make sure that we meet a lot of the style points to make it appear as though it was a historical home, just original to the Spanish colonial style, including a wooden balustrade. The second story itself is consistent with that style. The tile roof, the decorative parapet, the decorative architectural windows, and other architectural details like the lighting in the windows being in the older style. With regards to the comment that we would decrease the value by moving the house in this way, the statement didn't make any provide any proof for why that would be. And in my experience, as each home within the neighborhood renovates itself, the neighboring homes all increase in value. Now, with regards to the setback themselves, and hopefully I can do this properly, but I'm gonna share my screen, and it's going to be this one. As you see in my neighborhood, there is a distinct difference between homes that face 6th Street and homes that are more interior to the neighborhood. And with regards to the homes that face 6th Street, as I do, we're a little bit different than the rest of Sam Hughes because of the noise and the traffic that we have to deal with. And when you're facing 6th Street, the majority of my neighbors in the affected area where you sent out the mailers have elected to block the entrance to 6th Street, usually with some type of decorative wall or shrubbery, and it's fairly extreme. Of the 31 homes in the circled area, 20 of them have elected not to use their front yard. There's no parking. It's dangerous to be out in your front yard, and it's noisy. So what many people have done, and I've attached some photos, and I'm just gonna get to some of them real quick, is they'll block their front yard. And I've put many photos of my neighbors who have a completely blocked out front yard. Now, one of the comments, this is the one directly across the street from me. There is absolutely no access from 6th Street. They also go to the side. And one of the negative comments was that by allowing my house to basically rotate, to have the front of it face Wilson, that this isn't fair to my neighbors who aren't allowed to do the same. And as we went around, noted all of these homes that have blocked entrances that actually access their home, see block, they access their home through the alley that's in the back. And this is another 2nd story directly across the street. The west setback that I'm requesting is actually going to make it flush with where the house is now. So at some point, a variance must have been given to allow it to move to that point, and we're just going to make it a straight line. We're not going past where the house is already built. And then I believe Mr. Castro also demonstrated, I'm sorry, I'm going really quickly, that within the affected area, there are multiple homes that have a 2nd story. There's one, in fact, directly across the street from me. And you can see this is my front yard. And this is the 2nd story. It also has a veranda, as I'm contemplating. So I would be in line with that. And then the home directly south to me, I'll show that as well. This one right here also has a 2nd story, and it also has a balcony. So to say that I'm not in character with the neighborhood perhaps shows that they didn't really, well, anyway. Okay, so I'd just like to make an additional comment. There was a statement that because I would have the 2nd story, that I would be able to view my neighbor's yard. My neighbor directly to the west has already situated their house in a way that I would not be taking a view, and I'll stop sharing my screen for a minute. I would not be, I think there was a comment made that about the light and the air and potential for fire hazard. Where I'm planning to build my 2nd story would not impact my neighbor in terms of what they can see from their house already. Because when I purchased my house, they're already built in such a way that we're looking at each other regardless. The addition that I'm building, it would be over where they park. And the way that the light flows and the way that the shadow would hit actually would create shade for their car, but only during certain parts of the day. Mostly it'll go over the street. And that was just addressing some of the comments. And now I'd like to just make a general statement of, I'm from Tucson. I've lived here my whole life, and I've always wanted to live in Sam Hughes. It's, for me, no offense to other neighborhoods, but I love Sam Hughes, and I've always wanted to live here. And I wouldn't do anything that I believe would harm the neighborhood or degrade the neighborhood. And in fact, I don't know if you observed it within the plans itself, I'm preserving the interior, I'm preserving the current exterior of the home in the interior design. So I'm not tearing down any aspect of the home as it is. I'm building up around it. And it would be much easier and more cost effective to simply scrape the front of the house off and build a 2nd story right there. And then I wouldn't need the setbacks as I have them now, as I wish to have them. But I don't want to do that. I love the front of my house. And I don't know how many of you remember the old El Parador, where they took the exterior mall and turned it into an interior restaurant. Unfortunately, that's been torn down. But that's sort of the basis and the jumping point off from this design. I wanted to preserve my home and be able to enjoy it. Unfortunately, as the way it stands right now, my family can't comfortably live there. The interior of the home had been a rental for many years and has been split and divided up into a mini dorm situation. And I would like to turn it from this mini dorm that so many homes in Sam Hughes have been subjected to and return it back to a single family home. And right now, currently, I share a bedroom with my 9-year-old son, which isn't going to be working for much longer as he gets older. He's not going to want to share a bedroom with his mama. So we need additional bedrooms. We need more space. And the second story allows us to have these additional bedrooms. Finally, like I said, I do love this neighborhood, and I am particularly aware of how important my home is, because we're on the crossroads of 6th and Wilson, which is, first of all, on a major roadway, an artery, but it's also one of the bike paths that so many people enjoy through our neighborhood. And people cross by the side of my house constantly every day. So when we rotate the house to face Wilson and we put the decorative items, it will increase the neighborhood enjoyment, because as it stands right now, my house could use some assistance. It hasn't been updated, I think, for quite some time, and it needs some work. So we've done a lot of research in making sure that we keep with the historical style. I won't repeat myself, but we're going to be placing those in there. And I was really pleased that the president of the Sam Hughes Neighborhood Association came to our question and answer session regarding the plans. She came and she asked questions, and then she went directly to a meeting of their association afterwards. And I saw no objections from them. So that really was important to me, that the neighborhood association was in support of my plan, at least enough not to object to it. And I thank you so much for the time and opportunity to speak. And if you have any questions for me, I'm happy to answer. I don't know if that's part of this, but.
Well, thank you very much. You gave us a very good presentation. Let me first state, I don't have any questions for you. I'm comfortable with your request, but let me open it up to other board members. Do any board members have questions for Ms. Cornejo?
I do, Chairman Marks.
Yes, please.
Yeah, just a quick question. You had said that about the setbacks, that you said if you had done your development a different way, you wouldn't have had to worry about the setbacks. Can you explain more about that?
Right. So the front of how do I explain this? The front of the house, where I want to have the second story, is right now unusable space. And I wanted to change that to usable space. So I did want to have the second story there. I believe Mr. Castro's report indicated that if I built on the back lot, that I would be removing existing parking, which is true. And I don't want to do that. Parking is a premium in my neighborhood. So we're building in the front regardless. If instead of building around the current structure with steel beams, if I just took the front of my house off, like what the neighbor up the street did, then I could be slightly further back, and the height requirements on the sides wouldn't be impacted because we would be further back into the sides. But because I want to keep the original structure, which I love, it just doesn't work for me. We have to make it a little bit taller and a little bit wider, so that we can build around it and still keep it.
Okay, yeah, I understand. Thank you.
Any other questions from any other board members? Well, hearing none, I want to thank Ms. Cornejo and then ask, is there anyone else in the virtual audience, either in favor or in opposition to the request? And hearing none.
Oh, can you hear me?
Yes, I can.
I just wanted to introduce myself. My name's Scott Smart. I live at 1609 South Turquoise Vista, and I'm the draftsman that was hired by Maria to develop her concept that she had been working on with her parents, and I was the one that, developed it enough to, submit it to City of Tucson and obtain comments and, had discussions with Alyssa Hamblin and Lance Peterson. And so I might be better to answer some of the technical questions regarding the plans themselves. And so I just wanted to make myself known if I might jump in and comment on something if necessary. But I thought Maria did a good job explaining the project scope. And, we went through the entire process of the plan, of submitting, getting comments and finding out about how this project couldn't be resolved with just a DDO process. It required this process, the Board of Adjustment, because of its relationship to 6th Street. And like Maria said, there's a number of 2 stories in the neighborhood. There's examples directly across the street. I don't know if she was clear about this, but I think it's helpful to know that her property abuts 2 roads and an alley. And so the west neighbor is really the primary neighbor that is impacted the most by the height of the structure. And to my knowledge, there's been no opposition from them or comments from any of the direct adjacent neighbors, to her. And so that's a good sign in terms of that and stuff, because, we'd be probably thinking about the project differently if an adjacent neighbor had an issue. And so as far as style, I'm sorry, I'm bouncing around here, but that was kind of, that part of it. And then as far as style, we really feel like in that neighborhood, there are a lot of historic homes, but it's not a historic neighborhood where it's all architectural guidelines are, kind of governed by a review process. This one is, like Erica said, people that choose for tax reasons to get on the historic list, and they adhere to it individually as they develop their project and stuff like that. But in this neighborhood, there's many that are conforming to that and many that are not. And that's why there's a whole variety of styles and projects throughout the neighborhood. And particularly, you think about 6th Street as you drive down it, what Erica was talking about was many people choose to build walls around their front property line. So the character of the house, along that street is lost in many cases because they're got 6 to 8 foot high walls, blocking them. And the benefit is people plant trees and provide a little softer edge to, that street frontage. And so we feel that, what on our proposal, yes, it's tall. We will have a lower wall and we will provide, some vegetation in the front to soften its impact, on the street side and stuff like that. And that primarily the neighbor to the west, who hasn't voiced any opinion on the project, who would be most impacted by it, hasn't had an issue. And so I just wanted to make that clear.
Well, thank you very much. I don't have any questions for you. I appreciate your comments. And if any other board member has a question, they could ask that question at this point.
Yeah, I do,
You have
Mr.
one?
Chairman.
Go ahead.
Yeah. Mr. Smart, one of the criteria that we have for deciding what, deciding to provide a variance, we have, like your project looks great. There are many great things about it, but we have a very set criteria, right? We have like 8 things that we have to follow. But one of them is that the project is the minimum needed for we provide the minimum variance needed for the project. Can you talk about that?
We are requesting to the inch the minimum required. The setbacks have been. Can you hear me? I just wanted to make sure.
Yes,
Yeah,
we can hear you.
the setbacks have been, determined with Alyssa Hamblin, and down to the inch, because that's how that works. As the structure gets taller, the setback gets greater, and so we are requesting the bare minimum. And just a note along 6th Street for that is the one unique case where currently the house meets setback requirements, but because of the future right-of-way potential, that's why we're required, a variance for that particular one. And Lance Peterson and Department of Transportation has told us that in the next 20 years, they're not going to do anything to 6th Street, and that the current agenda is to actually reduce the width of 6th Street and change it to a one-way with a bicycle path. So they're, in the next 20 years, it's kind of stable, and we meet front yard setback, but it's kind of to be determined, what happens with that road in the future. So
I guess as someone who's, isn't, aware, I'm not an architect, it's very easy to say that the project could be changed by some feet to allow that, to be built without setbacks, right? Like that you could decrease the footprint size without having to decrease it. So in my mind, I'm trying to understand, how you can both, right? Like I understand that it's the project that you want to build, but our criteria is, does it meet the, is it the minimum that is needed? And that's a hard thing for us to, to reconcile, right? Not, like I said, not being an architect, what do we count as the minimum needed? And so I guess I was wanting you to speak to the idea that you could, that is the criteria that we're trying to look at.
Well, I mean, their site situation is specific on this one, where they have an existing home already, and they have a detached structure, and they have a detached garage, so that there's already, quite a bit of lot coverage, and so in order to, approach the project in a different manner would require demoing, and, getting rid of a lot of stuff. And of course, there's ways to do it. One factor, particularly on this lot, is it's 50 feet wide. So, things, as they get taller, the lot gets really thin, you know what I mean, in the middle, for that potential of a 2-story. But this was a design idea generated by Erica and her family, and we helped develop it. And, the reason why we're going through this process is because they love this approach, and, we're attempting to, voice our opinion on, its validity. So I hope I answered you, Lee.
Yeah. Now, this is Bruce Dawson. I do have a question or to point out a point I'd like to make is that one of the other criteria is that this is not something that has been afforded to any special privileges been afforded to other properties in the neighborhood. And like has been pointed out, there are plenty of 2-story buildings all over the place. And I don't really have any objection to any of this. So I don't see any special privilege being granted to you.
Okay. Does anyone else wish to say anything further before we close the public hearing?
Yes, hello. Can you hear me?
Now, who is that?
This is Bill Paulus. I'm here with my wife Audrey, and I apologize.
Well, no, I don't hear you very clearly, but see if you can get closer to where, the microphone and identify yourself, and then I need to swear you in.
Okay, hello. My name is Bill Paulus. I'm here with my wife Audrey Paulus. We represent the Paulus Family Trust.
Now, let me, before you go any further, ask you, even though I don't see you on a video, to raise your right hand, and do you swear to tell the truth and nothing but the truth?
Yes.
Okay. Could you
I
identify your interest, whether you're a resident nearby or not?
No, I own property nearby that's really under construction at the moment. Our residence right now is in La Cañada, California.
Okay. So what are your comments on this request?
Well, our comments, we wrote a letter, which I think you all have there, and our comments have nothing to do with the style of the architecture or the building. I was strictly concerned about the setbacks because some of them were extremely minimal, and I'm very concerned about the property to the west. The way is owned by an absentee owner who lives in Oxford, Mississippi, to my knowledge. And that property is rented out, so she may not have any issues now, but anybody who owns that property in the future may have very big issues.
So let me ask, you're saying you're interested on behalf of the owner of the property to the west, but you're not the owner of the property to the west, nor have you spoken to that owner?
I left 2 voicemails and never heard from that owner. That owner has only owned that property for...
I'm having difficulty hearing you, but go ahead. Now I don't hear you at all.
I'm sorry if you can't hear me. And I apologize for not having a camera.
I'm not sure the board members are hearing you at this point.
Sorry, what did you say?
Yeah, if you're speaking, why don't you continue and, try to come to some conclusion at some point soon. Yeah, I heard a voice, but I really didn't understand what you were saying. We're going to have to move on unless you can correct the audio conditions, because we really can't understand you.
Hi, this is Hi.
I don't know if anybody else can, but I cannot understand what you're saying.
Hi, this is Audrey Paulus. Can you hear me?
Yeah, I heard that.
Okay, so our concern are the setbacks, as we noted in our comments to the Board of Adjustment. We have a house on 7th and Wilson, so we are neighbors, and we are involved with that radius. So our concern that all the setbacks are too extreme, and that having a veranda on the 2nd floor having someone stand on the floor, the person could actually have a view into the west side facing property. The west side facing property is an out-of-state investor. We've tried to contact her twice without success, but we're speaking on behalf of ourselves because we're concerned about the setbacks that are extremely they're very extreme. So we've already presented a list of our comments, and I believe that everybody on the board has that, if I'm not mistaken.
Yes.
I think we can do is read it.
So do I need to read it or?
No, you don't. Could you repeat your names again?
So my name is Audrey Paulus.
Okay, yeah, we have your letter, and so we have read the letter you submitted, your comments, and yeah, there's a full page of your comments. I don't think it's necessary for you to read them to us again.
Okay.
But I appreciate your attendance and your the comments you have made. They are appreciated. If there's something further you want to add, please do. Otherwise, we'll move on with the hearing.
Well, a comment. My only other comment would be in regard to this house is very close to all the property lines and setbacks to the minimum. There really isn't any area for landscaping or any kind of screening. I keep hearing this referral to the property across 6th Street that's 2 stories, but that property has a lot of trees around it, and you really don't even see it unless you're looking for it. This house is going to really stand out because there's really no room to put any kind of growth to screen that 2-story addition. So that's kind of a concern to me because, like I said, the setbacks are minimal. The setback from the house on Wilson to the property line is only 4 feet, which is pretty much nothing.
We hear you. Okay. Well, thank you very much. Let me see if there's anybody else that wishes to speak. Is there anybody else in the virtual audience that wishes to speak to this item? Hearing none, I will close the hearing and I will turn to board members and ask if anybody wishes to discuss the matter or to make a motion.
Mr. Chair.
Was Mr. Dawson?
Yes, I move in the case of Cajero Residence, 2-story addition at 2246 East 6th Street, R1 zoning. I move to grant the following variances in this case. Allow the construction of a 2-story addition with a reduced front street yard perimeter setback from 26 feet 6 inches to 16 feet 7 as measured from the back future curb of South 6th Street. Allow the construction of a 2-story addition with reduced side street perimeter yard setback from 29 to 20 as measured from the outside edge of the adjacent travel lane along Wilson Avenue. Allow the construction of a 2-story addition with a reduced side yard perimeter yard setback from 17 feet 10 inches to 11 feet 5 inches as measured to the west lot line, and allow the construction of a 2-story addition with a reduced side yard perimeter setback from 15 feet 5 to 5 feet as marked in the west lot line. All is shown on the submitted plans. Subject to no conditions, the evidence presented to the board shows that there are special circumstances which are not self-imposed, which are applicable to the property and support the granting of the requested variances. The variances setback as set forth in the staff report, Board of Adjustment findings 1 through 7. The variances with no conditions will not materially detrimental to the public welfare or injurious to other properties or improvements in the neighborhood, and at the minimum necessary to provide relief.
Okay, thank you. That completes the motion. Is there a second to it?
Jesse Lugo, second the motion.
Okay, we have a motion and a second. All those in favor say aye. Aye.
Aye.
Aye.
All those opposed say nay. Hearing no nays, the motion carries unanimously, and that concludes that matter. So that being the only case on today's public hearing agenda, the hearing is closed, but we have one other item to deal with that is not a public hearing. And it is a request for reconsideration of a case that was decided upon last month. And let me identify that case. I have the agenda in front of me now. It is C10-22-02 White and Treadway Lot Line Adjustment. This is not a public hearing, but we will afford the petitioner, if he or she is present, the opportunity to convince the board that a reconsideration is appropriate for this case. Is the petitioner present? Is the petitioner for the Treadway and White case present? Hearing no one, I might seek some advice from staff or the city attorney, but I think the options are to just ignore the request, since we don't have an opportunity to be convinced that it's worthy of reconsideration because the petitioner is not present. Or we could act on the reconsideration, positive or negative, based upon what we know, which has been submitted to staff that we have become knowledgeable about. So if staff has anything further to say on my comments that I just made, then he or she can do that now. Otherwise, I'd open it up to the board members.
Chairman Marks, if I may, the request is for the board to take action on the reconsideration, regardless of whether the original applicant is in attendance or not. And you may base your decision upon the materials already provided to you by staff. I believe Mr. Lusk has his hand up, unless I just covered what he was going to say.
I thank you, Lee. Chairman Marks and board members. The board rules allow for disposal of the matter regardless of whether the applicant is present, or there's also the option to, on the board's motion, continue the matter.
Okay, so at this point, it would be in order for me to open it up to the board members to either discuss or for there to be a motion on whether to accept the request for a reconsideration. And if there was a motion in favor of reconsideration that was seconded and carried, then that would be all that we would do today. And the matter would then be scheduled for a hearing, presumably at the very next hearing date. And at that point, we can have the petitioner present to present the case. So it's open to the board to provide board member thoughts and positions and even a motion at this point.
Mr. Chairman, Jesse Lugo.
Yes, Mr. Lugo.
I was very clear as to what city staff had made the recommendation just to get approval to proceed forward for reconsideration. So I make a motion that we do grant the reconsideration, allow the applicant then to speak to the board once again.
Okay, is there a second to that motion?
I second that motion.
Yes, Mr. Dawson. I guess I should call for a vote. All those in favor say aye.
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 All those opposed say nay.
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 Could I have a roll call, Ms. Hamblin?
Sorry, just a second. Michael Marks,
Nay.
Bruce Dawson,
Aye.
Kathy Kubish,
Nay.
Jesse Lugo,
Yes.
Lee Pagney,
Nay.
Miranda Schubert,
Nay.
Irma Duran.
I'm not voting on today's board.
Okay, thank you. The motion fails. A simple majority is needed to move the reconsideration forward for a public hearing. I see our city attorney Jennifer, Ms. Bonham has her hand up.
Chairman Marks and members of the board, I believe we also need to state the reason why the request is denied per the rules.
You know, I don't think the audio was very clear for me, but basically I think what I heard from you is that the request is denied. Is that correct?
Based on the vote of the board members, the request is denied, but per the board rules, we need you to enter on the record the reason why the request was denied.
Okay, so, wow. So one person needs to summarize the reasons that were not expressed.
Mr. Chairman, Jesse Lugo.
Yes, Mr. Lugo.
Requesting those individuals who voted not to proceed forward to then make the statement as to why they denied the motion.
Well, I appreciate that. And I, for one, would say I don't believe I was presented with new evidence that was, well, first of all, new or substantive and relevant to the decision that was made last month. If the city attorney wants each one of us to speak to that, we could go through the, around the table. Mr. Pagney, do you want to say something?
Sure, a couple of things. One, specifically to answer the question at hand, I would say that, yes, I did not feel like I received new information. Then just a sort of a process-oriented comment. I think one of the things that I find hard about the board is that, like, for example, I would love to hear more about Mr. Lugo's reason for voting in favor. Like, I feel like there's probably some evidence that he has, and I would love to have more of a discussion around what that evidence is, so that I could be, take it into account. As it is, based on what I know right now, I felt like I could only vote in the negative. But I was wanting to ask my colleague what it was that he felt, and Mr. Dawson, what they felt were the evidence that was provided that was new, so that we could follow that process. But without a discussion, I felt like I couldn't do that. Thank you.
I appreciate that.
Mr. Chairman, Jesse Lugo, to answer that question, if I was in that position, each commissioner here, you're in their position, you would appreciate the courtesy to hear the information, because one thing, I don't like these virtual meetings at all. When we used to have person-to-person meeting, we can actually get to the nitty-gritty and get the questions answered directly from the applicant. So this is why, but again, this commissioners, just in my personal opinion, just don't understand the procedures here. As a courtesy to the public, I said, as appointed by whoever appointed you, should give the courtesy to these individuals that are applying for these applications.
Yeah, and I appreciate that, Mr. Lugo. I totally agree with you. I'm just think that for me, I'm trying to follow the standards that were given to us, and that there's 3 points that we have to make sure that one of those points is met. And I didn't feel like they were. And so if there was one of those that you felt like was met, I would love to hear what that one was met and how you felt it was met, because I could change my vote, but I feel based on the information I have, I didn't feel like those were met.
Well, it's not up to me to make that presentation, it's up to the petitioner to address the commissioners, not myself. I want to hear directly from that person. Once again, whatever information that he or she may have, information was omitted, hear it directly from them and not from myself.
Understood. Thank you.
Kathy, do you want to state why you felt, why you voted negative?
Thank you, Mr. Chairman. The proposed expansion of the lot line would completely cut off any parking to the eastern parcel. I've looked at this property, and if the petitioners were to build a wall, and he did suggest that was a possibility, the eastern parcel 86 West Simpson would have a very limited 4-foot sidewalk to reach their the front door that they've been using. It's my opinion that these folks are trying to get a second bite of the apple here. The evidence they presented, the legal description correction is relevant. And I mentioned that prior, so I won't reiterate that. But I don't agree with what they would do to the eastern parcel if this property were to go through. It's really a negative taking, if you will. Thank you.
And how about Ms. Schubert?
Yeah, just a few things. I understand that some folks may not be as comfortable with virtual meetings because of the format, but in my experience with these types of things, virtual meetings tend to be more accessible. I mean, you can even call in on your phone. You don't have to commute. You don't have to find childcare. You don't have to find parking.
2:48. Give me a call when you get a minute. Thanks.
Well, let's keep it to one at a time right now.
So I think that the accessibility of virtual meetings, the applicant isn't here right now. Our time is valuable. It's challenging to make these meetings, especially because they're in the middle of typical work days. So I also think that we deserve courtesy as commissioners. I also don't feel that I was presented with any new information. Today, I would have been very interested and open-minded to hear from the applicant about what additional information they think that we should consider. I also think that we already extended basic courtesy by continuing the item previously. So as you recall, we considered it. We didn't feel it passed muster, so we continued it and talked about it more. We've received an email purporting to have additional evidence, but it essentially is the same information slightly repackaged. So at this point, I just don't feel I have information that convinces me that we need to spend additional time on this.
Mm-hmm. Okay, very good. Ms. or Irma, you didn't vote on this matter, did you?
No, since I'm new to the board and I'm not,
No, I understand.
I don't have enough information. I asked Mark if I could not vote on anything today.
Okay, no, I understand all that. So let me ask staff and specifically Ms. Bonham, who I think asked for this additional information or explanation. whether that's sufficient, which she's heard from all of us individually at this point.
Chairman Marks, I believe that satisfies the board rules.
Okay. Okay, so that matter is disposed of.
No,
And
it's
that,
not. No,
that
it's
is
not.
everything on our agenda today.
It's not. I'm sorry. I'm not muted, so I'm gonna jump in here because I feel that what was submitted to the board in this last email from Mr. Castro was additional information, plus including some architectural drawings, which I did not see before. And also a display of the numbers of properties that were similar to the sizes of the property. This is a really old neighborhood, so there's lots of variances of what is and what isn't. Apply standard or sizes to things in the barrio because it's so varies so greatly, and a lot of these properties don't have any parking at all. I mean, it's was built before there were a lot of cars floating around, so I consider that there was sufficient things to apply for a rehearing, and I think we owe it to them to hear it again. If that's apparently not what the board thinks, so so much for that idea. But thank you for listening. I think there was sufficient information that it was given, and I think we ought to hear it again. So that being said, I'm done.
Okay, thank you, Mr. Dawson. So I think the city has heard an explanation of the vote from each one of us individually. And so I don't see anything further that we have to do on that matter. That is the only remaining item on the agenda. There's nothing else. And so unless there's some reason I'm not aware of, the meeting is hereby concluded.
Thank you, Mr. Chair.
Thank you, Mr. Chair and board members.
Yeah. Thank you to everybody.
Thank you. Have a good afternoon.
Everybody.
Thank you.
Thank you.
Thank you.
Thank you.